Welcome friends, AEFC 15. Argue in English fluently and confidently, part 15. In this special episode, I will give you the test of NCDRC to Supreme Court appeal. This is special. And before that, as usual, you should practice tenses. You have that folder, PDF file, and that PDF file contains 1000 legal verbs. Take any 10 legal verbs and practice that 3 multiplied by 4 tenses, 12 tenses. It requires 30 to 35 minutes. So this habit should be there till you are not confident you are fluent English speaking lawyer. After that, you can reduce this practice, but till that time, you should carry on this practice. Next page, I will give you 2 videos for finding out the difficult words. You have to find out difficult words with its meaning. And as usual, first watch, enjoy that video. Then search out. Second time, play, pause. Find out difficult word, challenging word, and find out its meanings. And then write that word with meaning 5 times each. And then use that into your own sentences. Such type of good exercise you have to do. And then at third time, you enjoy that video without any new legal words for you. So let me share you the video. Link is given in one folder there. So you have to copy that link and put that particular link into your YouTube browser and then watch that. Don't watch here, but because I'm not showing you full video, just I'm showing you just a test what exactly that video is. Just give me a few seconds. This is the video of Ravindra Bhatt, Justice Ravindra Bhatt's farewell ceremony. All speeches are good.
Justice of Orissa High Court for gracing the occasion. We are grateful to Sri and he was a judge of Delhi High Court.
Our SCBA President Adisha Agrawala. Then Justice Kaul, Sanjay Kishan Kaul. Then Justice Ravindra Bhatt.
A wise younger brother who is present here, who by his deeds and work inspires me.
He is very learned judge. All judges are very excellent in my court. But specifically, some judges are extraordinarily clever. So Ravindra Bhatt is one of them. So just watch this video. Now, second video also I am giving you of the same person. Ravindra Bhatt, Justice Ravindra Bhatt. In one memorial lectures.
21 by Justice Ravindra Bhatt on fundamental rights and the role of the regulatory state.
We are here to celebrate the memory of a person who, perhaps more than anyone else, worked for realizing the fundamental rights of his fellow citizens. Whether it was through his path-breaking work in intellectual property, including his interventions in the Novartis judgment, or through the organization he founded, IDIA, increasing diversity by increasing access to education. Shamnath dedicated his life to applying his knowledge
exist and are implemented on rotational basis between different panchayats. Show through this framework of interlocking vertical and horizontal reservations, the Constitution has imbibed principles of participation, fairness, equality, and different levels of governance. Of basic governance, I would add. What is the concept of fairness? For this, I would go back.
I hope you got the videos. Links are given in that particular folder. Watch it regularly. Find out the words as already I instructed before initiating these videos. Now, main part of our this 15th part is NCDRC appeal to Supreme Court. As per NCDRC rules and Consumer Act rule and section, 30 days are there to file appeal after the NCDRC order. And 30 days if cross, then section as per section 5 of Limitation Act, when sufficient cause is there, so Supreme Court can give the condonation delay if they think fit. So what is this matter? Exactly this matter is related to builder. In this two petitioners who filed appeal in Supreme Court now, this is statutory appeal. I will show you that appeal, everything bunchful. But they purchased a flat from one builder, and that builder have constructed so many flats, much more excess than their sanction limit. So obviously conjunction will be there. So they don't want that flat and they would want money back. So they go in RERA, then they go to NCDRC, and NCDRC rejected their claim, rejected their appeal, and imposed them fine because they have hide some material fact in the appeal. And now these people are in Supreme Court. But we have all the evidences. RTI evidence is there. I will show you that RTI evidence. RTI evidence is there. If this this particular builder have the permission of so and so construction of flat, but now he constructed so and so flats. So such type of good proofs are there. Then builder, then allottee builders agreement, everything we have attached as annexures to this statutory appeal. Let me share you the statutory appeal. This is final bunch of civil appeal in Supreme Court. Let me check whether it is shared to you or not. No, not share. Oh, okay. Now I'm sharing you. Yes, it is now shared. See, this is cost title, Amod Tyagi and others versus SKG Homes Private Limited. These two petitioner are the DSP level ASP, one is ASP, one is DSP in National Investigation Agency. But even though they are getting cheated by this builder. See, this is the index. We attach so many annexures. Communication between builder and LOT. 15 annexures we annex. And some additional documents which to NCDRC we have not attached. So additional document if we want to attach in Supreme Court, which in earlier court we have not attached. So we have to file a separate application for adding additional document, and with the leave of the court, then that can be added. This is a pro forma of listing. When anybody from you when give AOR examination, this format, everything will be very important for you. And there are my 3 books at present for AOR examination. Many people are using that books and getting AOR examination cracked. Some people are cracking in first attempt also. I'm not AOR, but my books are there in AOR, and in my law firm at present now 7 AOR are there, and non-AOR experts lawyers are near about 6 to 7. And so with the grace of Lord Krishna and with the grace of my Guru Nani Palkiwala, we are serving to whole India in all type of matters. Friends, this civil appeal is being prepared under Section 67 of the Consumer Protection Act, 2019. Read with the order 24 of the Supreme Court 2019, Supreme Court Rules 2019. Here is a typo error, 2013 should be there. Supreme Court Rules 2013. Against the impugned judgment and order dated 28/8/2023 in the consumer case number 10 of 2022 passed by the Honorable National Consumer Dispute Redressal Commission, NCDRC, National Consumer Dispute Redressal Commission, New Delhi. It is submitted that Honorable National Commission, there were total of 30 complainants. However, in the instant civil appeal, there are 2 appellants, Sri Amod Tyagi, serial number 24 in NCDRC appeal, and Prabhat Bajpayee, serial number 27 in NCDRC appeal. It is submitted that Honorable NCDRC was pleased to dismiss the complaint of the appellant, imposing cost of rupees 10,000 on both the appellant therein. It is respectfully submitted that Honorable National Commission has not appreciated the fact and circumstances of the case while imposing cost on appellant. It is respectfully submitted that there are following grounds which have not been appreciated by Honorable Commission. No sale deed has been executed in favor of appellant till date by respondent. That the appellant by filing the present civil appeal on the following points which shall be taken into consideration by this honorable court. Remember that in your drafting, in synopsis, you should give us some positive point which is related to your case, so that it is very easy to admit that case in Supreme Court of India. Physical possession by way of misrepresentation has been given to appellant by January 2019, keeping appellant in dark that the project of respondent is illegal. The UP Housing and Development Board has disclosed in the RTI reply dated 6/7/2023 that respondent was only authorized to construct 114 flats on the said land on which appellant have been allotted flat, but respondent have constructed 257 flats on the said land. This is given in RTI reply. It is submitted that incomplete physical possession without any amenities have been provided to the appellants in the January 2019 on the assurance that sale deed shall be executed later on when the occupation certificate and completion certificate be provided by concerned authority. But till date, OC and CC, occupation certificate and completion certificate, have not been obtained by the respondent builder. The flat have been not provided as per the promise made in advertisement in the brochure of flat even after the due date of completion of the project. So we annex here to this petition the brochure, advertisement, everything. We have to work very hard in Supreme Court, friends. Remember that. There is only agreement to sell executed between appellant number 1 and respondent date 21/7/2017 for purchase of flat. The allotment letter issued by respondent 2, appellant number 2 is of 4/10/2016 for the said flat. But till date, no sale deed has been executed by the respondent in favor of appellant. The construction of the project is illegal because OC, CC, occupation certificate and completion certificate, have not been granted by authority to respondent for the said project. The Merlin Sector 17, Vasundhara, Ghaziabad. So these are the main points, and some more points are there. You can read it properly. It is submitted that by DM Ghaziabad has also passed the order dated 27/12/2022 against respondent to attach the movable immovable properties of said project because of illegal construction done in the said project. It is submitted that demolition drives have also been initiated in the said project and respondent by the concerned authority because respondent has illegally constructed the project. So, Deputy District Magistrate of Ghaziabad also taken action. So these are the strong proofs in this. So these are the some question of laws. Hence, civil appeal is being filed. We have added these case laws. Then list of date is there. Take the printout of full bunch. Study this matter. If you complete all 16 part thoroughly, then you will get all knowledge of different law, different segment, different stream of the laws. These are the property matters. This is impugn order. Impugn order is very interesting. Huh? Go through that impugn order. Impugn order means NCDRC order, which we are challenging to Supreme Court. Some sound you are hearing, have puja sandal sound that. the all these 15 pages is judgment is of NCDRC. Then this appeal, our regular appeal. Appellant 2. Petitioner, appellant, you can say. Respondent, respondent. Some are contesting respondent, some are pro forma respondent. What is pro forma respondent? You know what is pro forma respondent? Try to remember. Suppose in NCDRC appeal, there are 30 appellant. And when that order is not in the favor of appellant, then we are challenging it to Supreme Court. But 30 appellant are not coming to Supreme Court. Only 2 are coming to Supreme Court. So we cannot hide the 28 balance appellant name and addresses. So we have to show to Supreme Court. So only 2 appellant will be in appellant and balance 28 appellant will be as a pro forma respondent. They will come into respondent, but they are pro forma respondent. They are not real respondent. They are not contesting respondent. They are pro forma respondent. So notice will be served only to contesting respondent, which builder and some government officials which are contesting respondent in this matter. So pro forma respondent means that appellant who are not coming to Supreme Court. So they have only we can show main appellant in appellant and balance 28 appellant will be in pro forma respondent. So that is the pro forma. These are the facts of the case. Main question of laws. Whether Honorable NCDRC has erred in law and facts in dismissing the complaint of appellant and imposing the cost of rupees 10,000. Whether the impugned judgment and order passed by Honorable NCDRC is in conflict and overlooking clause 1.2, 1.2, 8, clause 7.1 of builder buyer agreement dated 21/9/2017 executed between appellant number 1 and respondent builder. Whether Honorable NCDRC has erred in appreciating the fact that no sale deed has been executed by respondent in favor of the appellant and unfurnished flat without amenities have been provided by the respondent to appellant in which appellant themselves incurred lakhs of rupees to make it worthy living. Whether Honorable National Commission erred in law that builder project in which flat has provided to appellant is in the fact illegal construction and appellant have been allotted flat, keeping them in dark. Whether Honorable National Commission judgment is bad in the law that respondent has not obtained OC and CC, occupation certificate and completion certificate from the concerned authority, and despite that they have allotted the flat to appellant just to commit fraud with appellant by taking hard-earned money from them. So then grounds also there. Case laws, then affidavit, then these agreements. So all are annexures this. All these are annexures. See, brochure of the builder, what he committed, what he has committed in writing agreement, also written agreement, but what exactly he has given, everything is mentioned. This is a very, very good and strong case. But surprisingly, what happened in admission hearing, I will tell you later on. Hmm? All these are the annexures. Hindi documents are not permitted in Supreme Court, but we have attached translated document of that particular Hindi. But even though original document we are attaching with translated document, that is allowed. But only Hindi documents are not allowed. FIR, so many things are happen in this case. This is a very strong case, friends. But what happened in admission hearing, I will tell you. Uh, just wait. Let me show you full petition. Appeal to statutory appeal. Permission to file additional document application. See, here is ITI reply. It is a translation of RTI reply. Here it is given in E. 18 floor and 114 number of flat in plot number 13 GH1 were planned by the architectural planner, architect and planning unit V, Lucknow. 257 number of flat have been constructed by the developer on plot number 13 GH1. So when permission is of 114 flat, builder is constructed 257 flats, then how he will get this completion certificate? Huh? From the government, from the department. So he will not give clear title. So this is a fraud. Stand of petitioner is very correct. So this is the, this is a appeal full bunch. Now prepare 10 points for admission hearing. You have to do this work. Prepare 10 points. Which are the strongest, like RTI? This is the strongest point. Lordship, please turn on page number so and so. Here, construction is allowed to 114 flats, but builder have constructed this flat. Then second, third, fourth, all points. And on that day of admission, I went there with full preparation in before bench. But when I show them this, to few points, they listen. And they told me, Mr. Somani, do you know, same petition, same civil appeal against NCDRC, same order is already disposed and dismissed by this court in last week. Do you aware about this? And same bench dismissed that. But we don't have that awareness because that in defect clearing process, so we cannot entertain this because same is dismissed. See, bad luck. Here is the difference of the arguing process. If I argue earlier than that case, my case definitely I got admitted in Supreme Court. But unfortunately, out of that 30, two petitioner were come to me. But some petitioner go to another person, he hurriedly file that matter, not join proper document, they don't have the proper document, and then they dismiss that case. And so our case also get dismissed because same bench has dismissed that order. Then how they can entertain our order? So this is the bad luck of my petitioner also, appellant also. Bad. Sometimes that such type of bad lucks are there, even though their legal remedy is not exhausted, even though Supreme Court dismissed that case. Legal remedy is there. They have, builder have cheated them, they can file criminal complaint under section 420. And specific performance of contract also, they can file a civil suit for specific performance of contract. As per the agreement, builder has not given them the specified specifications flat, not given OC, CC. So all these are there, remedies are there. No botheration about that. But such type of strong case because of other lawyers' inefficiency. Sorry to say that all lawyers are in Supreme Court good lawyer, but some lawyers are hurriedly without joining proper document, filing the cases, and they are losing the cases. And then that will hammer us when we take so much good efforts to draft this case. My AOR, my drafting team, my research team taken a good efforts, but we lose this case. And I don't want to show that losing order to you. So I have not given that order to you in this folder. Sorry. But remember that our effort should be good. I told appellant, we will file a review petition, we will file curative petition. Two options are there, but appellant is not ready. So then we have given that file back. Such type of things are happened. My main contention is how NCDRC's order are challenged in Supreme Court, how we are drafting that matter, which annexure everything properly from index to final, everything you have. Practice it. And what is review petition? What is curative petition? That is the last part 16 of this course. Argue in English fluently and confidently in high courts and Supreme Court. Friend, such type of endeavor with the grace of Lord Sri Krishna and with the grace of my Guru Nani Palkiwala, I have done. I hope you are liking it. Share your comment, and if you like this course, share to other lawyer also to enlighten them, to law students also, when they will pass their degree, pass their law degree, and when they will enter in the legal practice as a lawyer, that time it will help them. Thank you. Thank you very much. Jai.